To make you the smartest person in the room, regardless of who else is in that room, I have to connect dots that nobody else does. And that's exactly what I'm going to do in this video. Specifically, I'm going to show how the United States Supreme Court in the Trump quote-unquote insurrection case dealing with the 14th Amendment, how they used historical laws versus the opinions of quote-unquote elite historians, and what we can learn about how they decide Second Amendment cases, because it's very insightful. It's also very important to see how 9-0, even Justice Brown Jackson rejected the views of a bunch of, over 24 historians that wanted them to throw Trump, frankly, under the bus. One of those historians, believe it or not, is actually someone who specifically wrote on the Second Amendment itself. You're not going to want to miss this video when we come right back. Hey folks, I'm Mark Smith, host of the Four Boxes Diner, proud American gun owner, constitutional attorney, member of the United States Supreme Court Bar, and author of many books, including Disarmed: What the Ukraine War Teaches Americans About the Right to Bear Arms. Okay, it's important that we learn the lessons of others. And part of what you do as a high-end lawyer is you look at what other cases in America are doing to try to see if there's anything valuable that you can use in cases that you're involved with. So in this context, where we talk all about the Second Amendment's right to keep and bear arms and we want to protect that, we want to see if there's other cases that may not specifically deal with the Second Amendment, but might be helpful to either teach about the Second Amendment or give us guidance as to how the Supreme Court, for example, is thinking about the Constitution. That's exactly what happened here in the Donald Trump case involving Colorado, where the state of Colorado and also the state of Maine and others try to keep Donald Trump off the presidential ballot for 2024 on the grounds that he allegedly engaged in insurrection or helped an insurrection on January 6th of 2021. Now, we're not going to get into the debate here. All we're going to do is, all I want to point out about this is the following, though. Everyone on the left, in the left-wing media world, was talking about how history was entirely on the side of the anti-Trumpers. There's articles, which I'll put a link to down below, that other people have flagged about how MSNBC, for example, would write articles called "Historians Support Voters' Case Against Trump in the Colorado Ballot Case." And I should note there's a wonderful Substack that was published by Ann Coulter where she lays out a lot of these expert opinions set forth by the left before the decision. And then you have a literally 9-0 unanimous Supreme Court decision in favor of Donald Trump over the interpretation of the 14th Amendment that says that the state bureaucrats, these state judges, these state Secretary of State's offices simply can keep somebody like Donald Trump off the ballot because they believe that he engaged in insurrection. And that, of course, turned out to be not the case. In fact, again, even the liberal justices of Justice Sotomayor, Brown Jackson, and Kagan rejected the notion that a state could kick off a presidential contender using the 14th Amendment of the U.S. Constitution. Now, of course, what I want to talk about here is what's important to understand is there were dozens, over 24 historians submitted briefs against Donald Trump, arguing that based on history, airy-fairy history, as we've talked about before, history, the 14th Amendment permits states from finding and concluding that a person engaged in insurrection and thus they could be kept off the ballot for federal elections. Federal elections, including, for example, an election to be the President of the United States. Now, the U.S. Supreme Court rejected all of that, again, including briefs, multiple briefs by historians claiming to say that under the 14th Amendment's history, Donald Trump could be kept off the ballot. Now, one of these historians that was on the anti-Trump side of things is someone we've talked about on this channel before. That is Carol Anderson, who wrote a book called The Second. That's right, about the Second Amendment. Carol Anderson's book, she's a professor, was entitled The Second: Race and Guns in a Fatally Unequal America. Race and Guns in a Fatally Unequal America. As you can tell, where she comes out on the Second Amendment, it's not where I'm sure you come out on the Second Amendment. And she submitted a major brief in support of Colorado, arguing that indeed Donald Trump could be disqualified for various reasons based on the brief. I'll put a link to it down below. You can check it out. That was in addition to a brief of 25 historians that said essentially the same thing. Now, what can we take away from all of this? the first thing I want you to understand is in the context of the Second Amendment litigations, as you know, once a modern-day gun control law is implicated by the text of the Second Amendment, the right of the people to keep and bear arms shall not be infringed, where the word infringe means to hinder, which means any kind of hindrance at all, triggers the plain text of the Second Amendment, which shifts the burden. Very important to remember that shifts the burden to the government. And what does the government do in a Second Amendment case to somehow justify the modern-day gun control law? Well, they have to come forth with historical analog laws. And this is extremely important to understand that because the Supreme Court, to some degree, did that exactly same thing here in the Trump case. Now, these historical analog laws are not to be equated with airy-fairy, generalized narrative storytelling by historians about what they think George Washington wanted or what they think Thomas Jefferson was thinking, any of these things. The history that the U.S. Supreme Court cares about in interpreting the Constitution as a general matter is actual historical laws. That's why if you look at the text of Bruin, and we've talked about NYSRPA versus Bruin quite a bit on this channel, they want a particular type of history. They want to see that the Founding Fathers in 1791, when the Bill of Rights was enacted, specifically enacted anti-gun, gun control laws of a particular type. They want to see the actual laws on the books that were actually enforced by Americans at the time of the founding. They don't want and they don't care at all about bringing in some historian like Claudine Gay, the former president of Harvard, to talk about their interpretation of history or their view of what history means or what they think Thomas Jefferson would think about a quote-unquote assault weapon ban. That's not what the Supreme Court cares about. They don't care about the opinions of these historians. But I should note, isn't it very interesting that over 24 historians submitted a brief against Donald Trump in this case, and the reality is they could not pick off a single member of the U.S. Supreme Court, including the left-wing members, including Justice Brown Jackson. I think this just really tells us just how out of step the modern academia in America is with the current Supreme Court, with some exceptions, of course, that may be really familiar and understand the Supreme Court, such as yours truly, but we're not going to get into that now. We're talking about others who don't like guns, who don't want you to have guns, and people like that. So going back to the Trump case, it's very interesting that these historians from these august institutions were not able to pick off a single justice, including any of the liberals, for their viewpoint. Now, I think this is very telling for many reasons. The first is, it really is important to understand how the left in America and many lower court judges in America really would like to live in a world where all they need to do is call to the stand or bring in an affidavit from some academic, from some Ivy League institution to tell some story about why it's okay to ban guns, why it's okay to have background checks, why it's okay to have licensing, why it's okay to have this gun control law. And certainly they would opine that Thomas Jefferson and John Adams and the like would be totally hunky-dory with modern-day gun control laws, even though at the time of the founding they enacted no such laws. So the first thing to understand is, again, that these historians don't count, but they want to be counted. In other words, the historians in America, many of them want to be counted to be the final dictator as to what the Second Amendment means. And there's many lower court judges that want to turn over the power to these academics and ask them to opine why the Second Amendment doesn't mean exactly what it says. That's why it's so important to understand how this works. But the Supreme Court specifically rejects that, not only Bruin, but they also rejected that approach in the Trump case. If you look at the Trump case, here is what the Supreme Court wrote. And what you're going to notice here is they're talking about actual laws on the book after the enactment of the 14th Amendment, which was enacted in 1868. They're going to talk about laws, for example, they're going to talk about things like the Enforcement Act of 1870. Specifically, let's see what the Supreme Court writes. And this is the kind of history they're looking for, actual laws on the book at the relevant time period. Let's turn to the record now. Instead, it is Congress that has long given effect to Section 3 with respect to would-be or existing federal office holders. Shortly after ratification of the amendment, Congress enacted the Enforcement Act of 1870. That act authorized federal district attorneys to bring civil actions in federal court to remove anyone holding non-legislative office, federal or state, in violation of Section 3 of the 14th Amendment, and made holding or attempting to hold office in violation of Section 3 of the 14th Amendment a federal crime. In the years following ratification, the House and Senate exercised their unique powers under Article 1 to adjudicate challenges contending that certain prospective or sitting members could not take or retain their seats due to Section 3. And the Confiscation Act of 1862, which predated Section 3 of the 14th Amendment, effectively provided an additional procedure for enforcing disqualification. That law made engaging in insurrection or rebellion, among other acts, a federal crime punishable by disqualification from holding office under the United States. A successor to those provisions remains on the books today, signed to the Federal Criminal Code. So you see here is an example where the U.S. Supreme Court is looking at actual laws on the books around the year of 1868 when the 14th Amendment was ratified. This is the same approach they used in Bruin in the sense that they want to see actual laws on the books. They literally don't care what 25 historians have to say about their interpretation of the law. Because keep in mind, for over 200 years, federal courts all across this great country have been interpreting the Constitution. They've been interpreting laws without the need for any kind of experts. And there's a good reason for this, because the reality is the entire job of lawyers and thus judges is to look for historical laws that help your client or help your case. Use those historical laws and apply to today's case. That's what the concept of precedent is. Legal precedents are exactly that. They're historical laws, they're historical decisions, they're historical cases that lawyers are trained to go back in time, get, and then bring and apply to contemporary issues. And of course, the classic example of the most important legal document that is not just applied every day, it's used every day, not just in political affairs, but everything we do in terms of running our federal government is the United States Constitution, which all government workers, for example, swear an oath to uphold. So the U.S. Constitution is the ultimate law of the land. And the fact that it's over 200 years old, almost 250 years old, guess what? Doesn't mean it's hard to understand, right? So again, the idea that historians are needed to interpret the Constitution as opposed to just using lawyers and judges to do their jobs is silly. We should also keep in mind the most famous example of a historian trying to influence the American gun debate is Michael Belisarius, who was a professor at Emory University, who wrote the famous book, The Arming of America. And guess what happened there? It turned out that a lot of his work was either shoddy or falsified. All sorts of terrible things happened. But here's the interesting thing, that Michael Belisarius was literally awarded the most important historical award that you can get as a professional historian. It's called the Bancroft Prize from Columbia University. He was awarded this prize. The historians, the top historians in America, gave him the Bancroft Prize, which is like the Nobel laureate for historians. It's like an Oscar for historians. And they gave it to him without even knowing or being able to catch the fact that he had falsified information, he had gotten things wrong, he had done shoddy work, and so on and so on. There's a whole list of the things he did wrong. You can take a look at the record yourself. I'll put some links to it down below if you want to check it out for yourself. But the point is, the historians didn't catch it. It required some lawyers and other gun-related experts to actually track some of the stuff down and start to raise questions. It was lawyers who caught the fraud and the problems associated with the shoddy workmanship and professorship and academic work of Michael Belisarius, who wrote, again, the famous book, Arming America. So again, the book Arming America gets debunked, and the academic research that went into that gets debunked by lawyers and people in the law, not by historians. Very interesting, very telling. So anytime people say that you need to trust the views of historians as to what the Second Amendment means, simply say, I don't need to do that, because the United States Supreme Court doesn't do it. Not only do they not do it in the context of the Second Amendment, they don't even do it in the context of the Trump case. What they do look at is actual laws on the book, which teach them what it means. That's why they're looking at, like, the Enforcement Act of 1870, an actual law on the books by the federal Congress, to tell them what Article 3 of the 14th Amendment, Section 3 means. Very telling here. The final point I want to make is the reality is, and this is a harsh reality, and I think the U.S. Supreme Court recognized this, the modern day academia, as a general matter, is overwhelmingly radical left-wing. I think that's the case with virtually all the fields associated with higher education. There's very few conservatives or libertarian-oriented people in these universities anymore. They've all been driven out. Either they never got jobs or they were denied tenure or whatnot. But there's no doubt that the credibility of a lot of these universities has been terribly hurt because there's no ideological diversity. When they talk about diversity, they're talking about diversity of maybe skin color or something like that, but they have no interest in ideological diversity, where half the history faculty is conservative, half the history faculty is liberal or anything like that. That's not what they're talking about. With that said, I think a lot of judges in America now recognize this reality. I certainly do, although I'm not a judge. I recognize the reality that you're simply not going to get that many conservatives writing for elite institutions or working for elite institutions. They're just not going to get those positions, not because they're not qualified, but because really they're never going to get in the door, because they're going to get shut out by virtue of the faculty that are already there that are just not going to let them in. That's just the harsh reality of it. And as a consequence, when you look at university professors and their views on various social issues, especially involving things like Second Amendment and guns, they're overwhelmingly going to be to the left, and therefore it's going to be very easy for the anti-gun community to be able to throw, dozens of anti-gun historians or people that will tell stories that are anti-gun or anti-Second Amendment. It's very easy for the left in America to do that because they control these academic institutions. It's much more difficult for conservatives to do that because so few of them are in these professions, not because they're not qualified, but because they can't get in as a practical matter. So that's just the harsh reality of it. So whenever you see historians disagree with your Second Amendment rights, or disagree with the Constitution, or disagree with this or that, always keep in mind where this is coming from. And remember what I taught you today is that the U.S. Supreme Court is interested in actual laws by our founding fathers enacted with respect to any gun control laws, which the reality is there are none. And that's, by the way, why the anti-gun movement in America desperately wants to undercut the Bruin methodology, because they simply cannot find gun control laws that justify modern-day gun control laws, because they simply did not exist. Those laws were simply not enacted by the founding fathers because they viewed the Second Amendment as a fundamental right. The right to keep and bear arms is a fundamental right, and therefore why would you enact a bunch of laws that restricted what the founding fathers thought was a fundamental right? And the anti-gun community and the left community in America absolutely hates this, which is why they're trying to get courts and others to embrace this notion of, we get to bring in a historian from some school to tell a story about why the founding fathers would like gun control, and that should be taken as truth. And that judges will simply delegate their authority to interpret what the Second Amendment means to these academic experts. But as we saw in the Trump case, dozens of these quote-unquote historical experts, or these historians, submitted briefs against Donald Trump, and the Supreme Court, even the left-wing members of the Supreme Court, really just kind of gave them the back of the hand and says, hey, thanks for submitting the brief, but we don't care, we don't believe it, it's not persuasive to us. So I think this is quite telling, and overall very good news for us in the Second Amendment community, because the last thing we want is for historians and others to come in here and try to rewrite the Second Amendment. We want the Second Amendment to be enforced as it was written by the founding fathers in the year of our Lord, 1791. So there you have it. Well, I hope you learned something here today about the connection between the use of history in the Trump case and the Bruin case and the Second Amendment cases. Make sure you subscribe. A lot of people keep getting knocked off the subscription list for some reason, so please subscribe to this channel. We're trying to get to 150,000 subscribers as fast as we can. We're working hard on it. Don't forget to follow me on X for more Second Amendment news at 4 Boxes Diner, and we will see you again soon here at the 4 Boxes Diner.
Orders up. Table 2A.